Hi there. My name is Young Advocate, and I'm here to take you through a law class session. Most times we have these very important lessons to make students aware of what the law is and the gaps that so many people have tried to make videos. I've had the advantage of watching so many videos, but you find these videos are lacking so much that the law is to expose to us. So in this class today, I'm going to take you through Contract 2 and majorly vitiating factors. But first, you will note that there are majorly around 5 or 6 vitiating factors. We have mistake, we have fraud, we have misrepresentation, and these vitiating factors are very, very important for students to know. We have coercion, we have undue influence, and we're going to start looking at them one by one after the other. And please don't forget to like, share, and subscribe my YouTube channel. You're going to find more of these videos there that are going to be so helpful to you. Once again, I'm Young Advocate. I'm going to take you through this class. So this class, we are going to focus only on mistake today. And in the other classes, we shall handle misrepresentation, we shall handle coercion, we shall handle undue influence. And all these vitiating factors, you're going to find my videos there. Just don't forget to subscribe to my channel. So first, we are going to define vitiating factors. So the term vitiating factors is a phrase used to refer to the situation which, when they arise, may nullify or vitiate an otherwise valid contract. That is the definition of a vitiating factor. So these are the factors or circumstances that invalidate otherwise a valid contract. So these vitiating factors are very, very important for you to note. And you will note that parties are free to negotiate their bargain in any agreement or any contract. Parties are free, and the courts do not interfere unless these vitiating factors are present in the contract. Now first, we shall look at mistake. And mistake, looking at our laws or statutes, we shall start with section 16. And but before we go to section 16, let's first open to section 12. And let's see what section 12 says together. And section 12, free consent to parties to contract, of parties to contract. Consent of parties to contract is taken to be free where it is not caused by A, coercion, B, undue influence, as defined in section 13, fraud, misrepresentation, or mistake, subject to section 16 and section 17. But I said in this class earlier on, our focus is going to be on mistake. So we are going to direct our attention to section 12, paragraph E, which says consent of parties to a contract is taken to be free where consent is not caused by mistake, subject to section 16 and 17. So to this extent, there are certain things that I want you to note. We are going to check section 16 and section 17, particularly what they read. So section 16 says mistake of fact. Those are the various categorizations of mistake. Mistake of fact. And section 16, paragraph 1, where both parties to an agreement are under a mistake as to a matter of fact, which is essential to the agreement, consent is obtained by mistake of fact and the agreement is void. One thing that you must note here is that the effect of mistake of fact, where both parties to an agreement are under a mistake of fact, which is very essential to this agreement, consent is obtained by mistake of fact and that agreement is void. And that is the effect of that mistake. It renders the agreement void. So here, two parties are entering an agreement, but both of them operate or are under a mistake. None of them knows that they are making a mistake, but they're under a mistake as a matter of fact, which is very, very important to this agreement. The mistake should be an operative one. That is what this statement, essential to the agreement, means. It should be an operative one. And for that reason, the contract will be void. So to that extent, I want to direct your attention to the case of Galloway versus Galloway. This case is very important for you students. It is an extended principle. It was a marriage case where two people were married, believing themselves to be married, we are living together, and when time for divorce came, these people were their ways parted. Now this man had promised that he was going to be paid. They will lend some money after the breakup. Then after some time, he refused to pay this money, and this lady brought an action. And then when they went to court actually found out that there was no, in fact, at first instance, there was no marriage. And therefore, these parties had entered this agreement to pay this lady. This man had entered this agreement to pay this lady time to time, thinking there was an agreement when there was no. Both of them thought they were married, and in the first place there was no marriage. And for that reason, court said that that agreement was void for mistake, because they were both mistaken to think there was a marriage when there was no marriage. So that is where both parties, that is the mistake of fact pursuant to section 16. Next, we are going to look at section 17. These are the various categorizations. But before we go there, let's read paragraph 2 of section 16. Section 16, subparagraph 2 reads that a contract is void where one of the parties to it operates under a mistake as to a matter of fact essential to the agreement or to the contract. Now you would note that they started with the effect of this contract where one party, for instance, me and you, or party X and Y, have entered an agreement, and party X is operates in this agreement, operates under a mistake. So that contract, if it is concluded, the other party that operates under a mistake will render the whole contract void. That is section 16, subsection 2. That is what it says. But, you know, there are also some things that you must know about this section. And this section will only work very efficiently where one party, for instance, party X, is operating under a mistake, and party Y knows that party X is operating under a mistake, but refuses or ignores the fact that he is supposed to make party X aware that he or she is operating under a mistake. I will get into a further detail and a further explanation of that as we move forward. Now, section 16, subsection 3, it reads that an erroneous opinion as to the value of a thing which forms the subject matter. I want you to note the subject matter, an erroneous opinion as to the subject matter of the thing which is the basis of the contract. That subject matter shall not be deemed as a mistake of fact. Okay? One thing you must understand in this concept, or in this particular paragraph, is that now you have an erroneous opinion as to a value of thing which forms the subject matter. For instance, I have a phone, but then when we were concluding our agreement to buy this phone or sell it off, I made an erroneous opinion about the phone. Now, what our laws of Uganda are telling us is that erroneous opinion that I've made about the value of the phone, so that erroneous opinion must be about the value of the phone. For instance, I say the phone is, let's say, $10, but it's supposed to be, in fact, $20. I make an opinion which is erroneous about the value of the phone because it is the subject matter of our contract. So I make an erroneous opinion about the value. I say the phone is $10 when in fact it is $20. So I make an error. So now our laws are saying that error as to the value of the phone shall not be deemed to be a mistake as a matter of fact. That is very important for you to note. Authority to that is the case of Bell versus Lever Bros. So Bell versus Lever Bros Limited explains this idea of erroneous opinion as to subject matter very well. So it does not render the contract void when there is an erroneous opinion as to the value of the thing that forms the basis or that forms the subject matter of the contract. It does not render the contract void. That is very clear. So now if you look at the case of Bell, the facts of that case were that the appellant was appointed chairman of one of the subsidiary of the respondent company. So he subsequently engaged in business activities that were in breach of his service contract, for which he would have been dismissed without any compensation. So now the parties subsequently entered an agreement for which the appellant was supposed to be resigned from office, and they were supposed to compensate him £30 as a compensation for loss of office. So neither of these parties was aware that it was open for the company to dismiss the appellant without compensation, without the £30. So both parties believed erroneously, okay? The statement is erroneously. Both parties believed erroneously that the Fresh Start Agreement was necessary to discharge, okay, the service contract of the appellant. So now what happened in this case was that now this went to court, and the company, having discovered that there was actually a mistake in this contract, the company sued the appellant. So now this is the decision, and it is a very, very important decision. So the House of Lords actually in this case gave a very, very great judgment. They held that the contract was valid and binding, and the mistake of the parties was insufficient to render the contract void. You remember earlier on I said, mark, and you must note that the parties believed that a Fresh Start Agreement was very necessary. It was an erroneous belief or opinion that a Fresh Start Agreement was very, very important, and was still. Neither of the parties actually was aware that the company could actually dismiss the appellant without compensation for what he had done. So for that reason, the House of Lords were very clear that the contract was actually binding, because it was just an erroneous opinion, a mere erroneous opinion, which could not render the contract void. Okay, and now what you must note very importantly is the judgment of Lord Acting. Lord Atking, when he stated that it will be wrong to decide that an agreement to terminate a definite specified contract is void if it turns out that the contract had already been broken and could have been terminated otherwise. So what Lord Atkin said was that it is very wrong for you to terminate an agreement to break a bigger contract if the contract was going to be terminated otherwise. It is very wrong. So now, what I want you to note very, very importantly is this decision now. So I want you to note very importantly this decision of the court. And this is the most important decision that you must read and appreciate to its full flavor. So the court was the view that in order for a mistake to qualify to nullify a contract or an agreement, it must render the subject matter essentially different or radically different from what it was believed to have been. That is very, very important for you to note. For a mistake, an erroneous opinion to render a contract invalid or void, it must make the subject matter or the thing that forms the basis of the agreement totally different, radically different from what it was believed to be. If it was believed to be, for instance, the contract was formed and we believed that you were selling me an iPhone, yet in fact you were selling me something that is totally different, not a phone even, you know. Now that is an erroneous opinion that can render a contract completely void. I think to that extent we are together. And now, going forward, we are going to look at the different types of mistakes. And now, we have 3 types of mistakes. We have common mistakes, we have mutual mistakes, and lastly, we have unilateral mistakes. So we are going to be exploiting these types of mistakes one after the other. So first, to start with, we have common mistake. And this kind of mistake is actually divided into 2. We have res sua and res extincta. And very important for you to note is that this res extincta and res sua actually fall under the umbrella of common mistakes. So that type of common mistake has 2 divisions. We have res sua and res extincta. And res extincta is where actually both parties who are entering this agreement enter agreement, form the contract without knowing that actually the thing for which they are contracting doesn't even exist. For instance, if I'm contracting with you, I form a contract with you, believing that you're buying a phone and I'm selling to you a phone, and we enter this agreement thinking there is a phone. Of course, we knew there was a phone, but now we are thinking that this phone is there, you know. You saw me with the phone, I kept it in my room, but not known to us, the phone has already been stolen. At the time we're entering this contract, we think that the phone is there. So now we are concluding this contract, we're forming the contract. And we negotiated, and now my phone is there. So I told you already that the phone is there. I'm going to bring it. It's yet on charge. You know that the phone is there. I too know that the phone is there. It's on charge. So now by the time we're entering this contract, the phone is already stolen, but not me or you has an idea that the phone is already not there. So that is res extincta. So when we form that contract, it is actually a void contract. We enter that contract thinking that the subject matter is there, or the thing that forms the basis of the contract is there, when in fact it is not there. That is very important for you to know. That is res extincta. So now, we shall start with authority to that. We shall start with the Sales of Goods and Supply of Services Act. The laws are very important. Then we shall go to a case law. Under Section 7 of this Act, the heading is actually reads, goods which have perished. So where there is a contract for a sale of specific goods, and the goods without the knowledge of the seller have perished at the time when the contract is entered into, the contract is void. That is what the law says. So where the seller is selling goods to a buyer, but the seller is not aware that the goods have perished, or the goods have been stolen, or otherwise the goods by any means have been lost, or they are not there, but the seller is not aware, at the time of entering the contract with the buyer, that contract which they form shall be void. Now we have a case that explains this principle very well, and I invite you to appreciate this case. And this case, actually, when you appreciate it to its full flavor, you're going to understand the concept of res extincta so well. Authority to Section 7 of the Sales of Goods and Supply of Services Act 2018 is actually backed up with the case of Cauterio versus Hasty. This is a very important case about res extincta. And in this case, the plaintiff sold a cargo of corns to the defendant. Unknown to either of the parties, or not known to both of the parties, a few days before the contract was made, the cargo, which was on aboard a ship, had overheated. And for that reason, the cargo actually fermented. Now, when these parties were entering this contract, they had no idea that the cargo was already sold because it had overheated and fermented. It was beginning to ferment. So the driver, or the person who was exporting this cargo, actually did sell this cargo by the time these parties were entering this contract. So the cargo did not exist at the time the parties were forming this contract, or were actually concluding this contract. So this is what the court said. And this judgment this decision is very, very important for you to note. It was said that the contract was contemplated, that the goods sold actually existed, yet in fact they did not. The goods sold, that is what the court said, that it was the contract contemplated that the goods sold actually existed, yet in fact they did not exist. So the seller could not therefore be required to deliver the goods, and the buyer had no obligation to pay for them. That is what the court said in that case. And it is very, very important for you to know that even if both parties to an agreement conclude the agreement, but they contemplate, or they believe that the thing that forms this agreement is inexistent, yet it is not, and they go ahead to conclude a contract, that contract is void because of mistake. And that mistake is very operative. That is res extincta. And I hope to that extent it is very clear. We have so many other cases. And now, before I move forward, I want you to note, as earlier on I had already said, that an erroneous opinion does not actually render a contract void. An erroneous opinion as to value of a thing does not actually render a contract void. And earlier on I talked about the case of Bell versus Lever Bros Company, and I told you the situation or the circumstance where an erroneous opinion as to the value of thing can render a contract void. And I said that the court in that case noted that where the thing is completely or radically different from what it is believed to be, then the contract will become void. That is very important for you to note. So we are done with res extincta, which falls under the umbrella of common mistake. So we are going to importantly look at res sua. I told you they have two divisions, and res extincta is already handled, and we're going to look at res sua, and we shall exploit it. So first, about res sua, what you must know is that resure is actually party X and party Y are going into an agreement, they are concluding a contract, but not known to party X. He or she is buying his own property. For example, I own a television, and the television perhaps is now with you, but by what means I don't know. And then I'm buying it from you now. I come and tell you, you know what, I want to buy your television. Thinking that it is your television, yet it is my television. Party X thinks that he's buying Party Y's television, yet in fact he's buying his own television. He doesn't know, or his phone. That is the best example I can bring to your attention. So authority to that is the case of Cooper versus Phoebes, and that is a very important case. A nephew had leased a fishery from his uncle, who later died, and when the time for renewal of the lease was due, he actually did so with his aunt. But not known to him or any of the parties, the late uncle had actually already made the fishery his, had already given the fishery to him. So he was actually, in other words, leasing what belongs to him, what was already given to him by his late uncle. And now when they went to court, it is very, very important for you to note this decision of court. So the court actually said that the contract, the lease contract or the lease agreement was void. And it was void because the party was actually buying or purchasing something or leasing something that belongs to them, and that is resure for you, and that resure actually makes the contract void or voidable sometimes. That is the effect. Sometimes it is voidable at the option of the wronged party. You, who is the wronged party, has the option of leaving the contract or staying in the contract. And the effect of res tincta is one, and it is not changed and doesn't change. It is void, it renders the contract void, and that doesn't change. But the effect of resure might be different. It may render a contract voidable at the option of the wronged party. It is very important for you to note that. So going forward, we're going to look at, I'm going to give you more cases about the principle of res extincta. And now I want to bring your attention to the case of Galloway versus Galloway. I had already earlier told you about this case of parties believing themselves to be in marriage or married, and they entered in the separation agreement by which a man undertook to pay money of maintenance to his woman. And when this transpired, they had never been married in the first place, but they believed themselves to be in marriage. So they entered an agreement of separation, and this man had actually agreed to pay this woman some amount of sum for upkeep or sustainability, you know. So now, when this man refused to pay this money, this woman came to court, and what the court said was very, very important. It is actually an extended principle of res extincta, where both parties believe that something to be there when it is not there. At the time of entering a contract, we believe that there is cons, the cargo is there. Both of us believe that the cargo is on the way coming. We concluded a contract, but to our dismay or to our surprise, there is actually no contract. The contract is void because the thing for which we were contracting actually does not exist. That is very important. So in this Galloway versus Galloway case, these parties believed themselves to be in marriage, and they entered a separation agreement. And part of the agreement was actually that this lady was supposed to pay, this man was supposed to pay this lady a sum of upkeep after the separation agreement. But now when they came to court, court said, in the first place, there was no marriage. They only believed themselves to be in marriage, and they were mistaken as to the marriage. So that court said to that extent that there was no contract between these two parties. So this man was under no obligation to pay this lady any sum of or any amount of money for which they had contracted. Another case that is very important about the principle of res extincta is the case of Acham Plumbers and Associates Limited versus Drury, and this Drury Uganda Limited. And this is a very, very important case for you to know. Both parties entered a contract, subcontract, in a mistaken belief that there was a bigger contract between the defendant and Uganda Wildlife Authority. And let me explain the facts of this case very well, because you may get confused somewhere if I do not. So now, Ocham Plumbers and Associates versus Drury Limited, actually, both parties, Ocham and Drury, entered a subcontract. It was a contract. They formed a mini contract between themselves, believing that there was actually a contract, a bigger contract, between the defendant, that is Drury, and Uganda Wildlife Authority. Let me bring it closer to you once more. Drury actually believed that they had a contract with Uganda Wildlife Authority, and for that reason, they now came and formed another small contract with Ocham Plumbers and Associates. So now, this contract with Ocham Plumbers that was concluded under the belief that there was actually a bigger contract between Drury and Uganda Wildlife Authority was said to be void by the courts. They only believed, for instance, let me bring it a little bit closer because I feel that this is a very, very important case that students will understand and students should know and appreciate so well. Let me bring it more relevant with a recent live examples that are around you. So what I mean here is, me, Party X, enters a contract with Party Y because I believe that there is actually a bigger contract between me and Party Z. You understand the point? And now what I mean here is, now you formed a contract. I formed a contract with Party Y because I believe that there's actually a bigger contract with Party Z. You know, yet in fact there's actually no contract yet. There's no contract between me and Party Z yet. It is only a mere belief that made me enter a contract, a smaller contract with Party Y. So for that reason, that contract will be void. That is very, very important for you to note. Now I want you to understand the judgment of Justice Bamwine in that case of Ocham Plumbers. This is what Justice Bamwine stated, that from evidence presented to the court, by the time the plaintiff and the defendant entered into the impunged agreement, the matter between the defendant and Uganda Wildlife, or the contract between the defendant and Uganda Wildlife Authority, in the lawyer's speak, shall subject to the was still subject to a contract. So what he meant there was, what the lawyer, Justice Bamwine actually stated that what the lawyer, from the lawyer's statement, what the lawyer said actually made it so clear, and it spoke out that the contract between the Drury and Uganda Wildlife Authority was actually yet to be concluded. Uganda Wildlife Authority had not yet made their mind so clear that yes, I have a contract with Drury. It was just yet a speculation. It was not yet a contract. But now Drury had believed that it was a contract, and for that reason, Drury went into a contract with Ocham Plumbers and Associates and concluded the contract. Now, the most important thing for you to note is just the effect of that mistake. It renders the contract void, and that is what happened in this very same case. So now, going forward, we shall look at another type of mistake. I told you there are three that we had already handled. Common mistake, which covers res extinct and res sure. Now we're going to look at mutual mistakes. So mutual mistake is another very, very important kind of mistake that you must know. And in mutual mistake, both parties are at cross purposes. The offer that is made and the acceptance of the offer are actually two different things. That is very, very important for you to note. The offer does not rhyme the acceptance. Now, me, Party X, is actually making an offer to buy iPhone, let's say iPhone X. Party Y, that is my offer. Party Y is actually accepting my offer, but the acceptance is for iPhone, let's say iPhone 8, you know. But we both don't know that we are mistaken. That is very, very important for you to know. Now, this principle is actually so much explained in the case of Raffles versus Witcher House. In that case of Raffles versus Witcher House, it is very, very important case for you to read and appreciate. And that case actually speaks out about mutual mistakes where both parties are at cross purposes. Party Y is making an offer for a different thing, and Party X is making acceptance for another thing, altogether forming different offer and different acceptance. That is very important for you to note. In Raffles versus Rachel House, there was a contract for sale of cotton bales to arrive PLS expert from Bombay. So there were two ships in this agreement, and one ship actually was leaving Bombay at December, and the other one was leaving Bombay in October, but they had the same name. Both ships were called PLS. So now the seller actually made offer. The seller meant the other ship made an offer to buy goods from the other ship that left in December. Meanwhile, the buyer actually made an acceptance for the other ship that left in October. So now the offer and the acceptance were two different things. So now this is what the court said. The court stated that the contract was void for fundamental mistake and mistake of fact that had prevented formation of an agreement. That the offer and the acceptance did not match. So now the court was saying that this contract is void because of a fundamental mistake that made it void, fundamental mistake as of fact. Because the offer and the acceptance, offer for December, acceptance for October, and these were two different things. Though the ships had the same name, the offer and acceptance were two different. So now, this is what you must note. For a party that is seeking to rely on mutual mistake, this party must be able to show some ambiguity or some degree of ambiguity that it was impossible on applying the objective test of a reasonable man that the parties intended to be bound by the set of terms of this contract. So what this statement actually means is that for you to rely on mutual mistake, you, the party that is trying to or wants to rely on mutual mistake, must show that there was ambiguity, that the other party made an offer for this and I accepted for this, or I made offer for this and the other party accepted for this. That ambiguity must be shown in that by the party who wants to rely on mutual mistake. And if that ambiguity is actually brought out, it must be understood by a reasonable man. A reasonable man must be able to say, from an objective point of objective test or from an objective point of view, must be able to say that there is actually no contract. The other party meant this and the other one meant this, which are two different things. That is very, very important for you to note. Now, going forward, I want you to understand the principle of unilateral mistakes. That is the last kind of mistakes we shall be looking at in this lesson. And as I said, we are in various classes in this YouTube channel. We are going to handle misrepresentation. That is very, very important for you to know. We are going to handle coercion. We are going to handle undue influence. Just do not forget to like, share, and subscribe to my YouTube channel, and you will find more of these important videos for you to understand this principle of contract 2, the vitiating factors, and I'm going to, in some videos, make videos about breach of contract, and those are going to be very helpful to students like you. I'm exposing these principles to you. Please don't forget that supporting me is also another thing for you to do while I do support you, because we share knowledge. It is very, very important. So now we are going to look at unilateral mistakes. It is very important for you to understand this principle of unilateral mistakes, and this unilateral mistake is actually divided into two categories. Unilateral mistake is in one form mistake as to identity, and then mistake as to a statement. You know, now in understanding unilateral mistakes, there is something very, very important for you to know, that you may make a statement. Okay, I may make a statement to you, then I make a mistake in my statement, but you are aware that I've made a mistake when we are forming this agreement. But instead of correcting me, you are now induced, or you rush into an agreement with me, knowing that I've made a mistake in my statement, and you do not correct me. So that is going to be a unilateral mistake. Otherwise, what I'm saying here is, for a party to rely on unilateral mistake as to mistake of statement, the party must be able to say or show that actually the other party was aware of the mistake that I made. You were aware of the mistake that I made, but you went ahead and concluded a contract with me instead of correcting me of my mistake. Now, this principle in the case of Hartog versus Collin and Sailed, it is a very, very important case for you to note and read and appreciate. Now, the defendant made an offer in writing to sell the plaintiff 30,000 Argentinian skin vibes. So the price was actually the one that was now a mistake. The earlier on made a contract orally. These two parties met and they made a contract to sell skins, Argentinian skins. And when they formed the contract, the price was actually labeled in pence per pound. Pence per skin rather. It was pence per skin. Now when they were actually reducing this contract into writing, there was a mistake now made. The agreement was different. It was pence per piece. That was how the price was supposed to be. But when it was reduced into writing, they made a mistake. And the party who wrote the agreement actually wrote pence per pound instead of pence per piece. So that mistake, when that mistake was seen by the other party, instead of correcting the other party, this party decided to enter a contract very quickly, concluded the contract, and was induced in this contract. And then after, the other party refused to deliver the skins, the Argentinian skins, and this other party had to sue. And now let's see what the court said in that case. It is very, very important. The court held that there was no contract since the buyer had known or had to know that there was mistake in the offer that was made by the seller. So the buyer had known or had reasons to know or had reasons to believe that actually there was a mistake in saying pence per pound, because earlier on we had formed an agreement, and in our agreement earlier on we said it's supposed to be pence per pound, but pence per piece. But now when we reduced it, it is pence per pound. What possibly would have happened? Which means the writer of this agreement actually made a mistake. I'm supposed to go ahead and correct the other party, but the buyer here actually did not correct the other party, instead rushed into agreement and concluded. Now the court said that contract was void because actually there was the other party knew or had reasons to know that actually this contract was there was a mistake made by the other party, and this contract was for that reason void. So now I actually said it is very, very important for you to know the other side of it. Mistake as to identity. That is mistake, unilateral mistake as to a statement. That is a unilateral mistake as to a statement. The other one is a unilateral mistake as to identity. And we have so many cases that explain this principle very well. And for now, we are going to end here. Mistake as to identity, I'm going to give you cases to read. And now we have come to the end of our session. And for mistake as to identity, we have the case of King's Norton Metal Limited Company versus Edrich and Merit. Read that case, please. I invite you to also read the case of Candy versus Lindsay, the case of Phillips versus Brooks, the case of Ingram versus Little, Lewis versus Avery. These are very important cases for you to read and appreciate. Citibank versus Brown and Company. It is very, very important for you to know. But to sum up with mistake as to identity, where one party comes on and he says I come to your shop and I tell you I'm Fig for Micah, yet I'm not Fig for Micah. Now you believe that you're contracting with Fig for Micah, yet in fact you're not contracting with Fig for Micah. I lie to you. I know that I'm lying to you by telling you that I'm Fig for Micah. And for you, you have never seen Fig for Micah, but you believe that you're contracting with Fig for Micah. So you go ahead and conclude the contract with Fig for Micah. And before you know, Fig for Micah has gone away with your good, but he has offered you a fake check. You know? Now, but there are two conditions that must be met or must be fulfilled before you can successfully claim a unilateral mistake. And these are the elements, or these are the key concepts that you must know. You must have intended to contract with someone, yet you ended up contracting with another. For instance, you intended to contract with Fig for Micah, yet you contracted with Kasule. That is one thing that must be met. For you to claim a unilateral mistake as to identity, you must have intended to contract with Fig for Micah or someone other. Then you ended up contracting with another person. Then the identity of that person was of fundamental importance. The identity of that person must be of a very, very fundamental importance. Very, very fundamental importance to you. That is, those two conditions, if they are met, then a party can successfully claim unilateral mistakes. So I told you earlier on, I want you to appreciate these cases. Now I want you to also read about documents mistakenly signed and the plea of non est factum. You sign a document, and to that you're going to read the case of Saunders and Anglias Building Society. These are very easy cases for you to read and appreciate. So I thank you so much for being here with me for this session. And once again, do not forget to like, share, and subscribe to my YouTube channel. I still remain Young Advocate, and that is the end of our session.